And welcome. We are pleased to present today's webinar, Two Swings and a Dismiss, Disability Rights Cases in the U.S. Supreme Court's 2024-2025 term. And it's brought to you by the ABA section on civil rights and social justice. The webinar is part of CRSJ's commitment to highlighting and sharing updates on key civil and human rights issues through accessible public programming. To learn more about upcoming events and on-demand programming or other resources, visit americanbar.org/CRSJ. A few housekeeping matters before we begin. One is we would ask you to please submit any questions you have through the Q&A function and not the chat. We'll get to as many questions as time allows. Some we may respond to in the Q&A itself, and some we will bring to the broader attention of the group as we think appropriate. If you don't see Zoom controls on your screen, chat, Q&A, captions, etc., try moving your mouse or tapping the screen. That should help. And for those of you who are hoping this program provides CLE credit, sadly it doesn't. So you won't be getting CLE for this. The program is being live streamed on CRSJ's YouTube channel, where you can watch immediately after the conclusion of today's program. Why you would want to do that while being on the program, I don't know, but I wanted to let you know that's a possibility. A recording of this webinar, along with resources that the panelists have identified, will be posted online soon and shared with all registrants. So please consider forwarding to your interested colleagues to help us expand the reach of this important conversation. So let's begin. And I'm first of all pleased to introduce the panelists for today's discussion. We'll be hearing first from Caroline Wick, who is the acting director of the Disability Rights Law Clinic at American University's Washington College of Law and a practitioner in residence there. And she will be discussing the A.J.T versus Osseo Area Schools case. Then I will be speaking on the Stanley versus City of Sanford, Florida case. I am a professor of law emeritus from American University, Washington College of Law, and co-chair of the Disability Rights Committee of the ABA section on Civil Rights and Social Justice, and chair of the ABA Commission on Disability Rights. And full disclosure, Carolyn and I were co-teachers in the Disability Rights Clinic through 2023. And our third panelist, and I should say the inspiration for the title of this webinar, if you thought that was cute, is Kiran Zucker. Kiran is a professor in the Department of Accounting at California State University, Northridge, or CSUN. And the way we have designed this program is I will start off asking some questions of Caroline, who will then go through some important aspects of A.J.T. I will talk about Stanley. Kiran will talk about LabCorp versus Davis. I will talk briefly about a case that was not decided, but on which cert was granted, death penalty case called Hamm versus Smith. Then we'll have some back and forth among us, and at the end, there will be time for questions from the audience, and we hope you will enjoy the presentation. So with that, Caroline, I'm going to start with you and ask you to tell us a little bit about the facts and the background of A.J.T versus Osseo.
Sure. So in this case, it's centered around Ava, who is a student with a disability. She has severe epilepsy and has multiple seizures in the morning and can't attend school until noon. She lived with her family in Kentucky and received extended instruction, meaning that she was taught in her home after typical school hours. She and her family moved to Minnesota, and the school district there refused to provide extended instruction for multiple school years. Eventually, she and her family brought a successful case under the Individuals with Disabilities Education Act, and then she and her family sued the school district for disability discrimination under Section 504 and the Americans with Disabilities Act, two federal statutes that protect people with disabilities.
And I think later on we'll be getting into some of the issues, maybe why somebody might bring an ADA 504 case after already having brought a case under IDEA. But for now, why don't you tell us what the issue in the case was and what the court held?
Certainly. So I'm actually going to share my screen. And can you just give me a second?
Always the fun technology part of the program.
So
there we go.
Excellent. So the issue before the court was what standard applies when plaintiffs bring educational services discrimination claims under the ADA and or Section 504. And really, does a heightened standard of bad faith or gross misjudgment apply? So Ava and her family sued in district court. The school district won a motion for summary judgment, arguing that the bad faith or gross misjudgment standard should apply. The family appealed to the Eighth Circuit, where the district court's decision was affirmed. So I think it's helpful to, a chart could be helpful here for understanding the issue in the case. Essentially, prior to A.J.T, different legal standards applied under Section 504 and the ADA in different contexts. So in all contexts besides educational services cases, when a plaintiff requested injunctive relief, then the plaintiff simply needed to show a statutory violation. When the plaintiff was requesting compensatory damages, then they had to show intentional discrimination or deliberate indifference. And deliberate indifference requires showing that the defendant was deliberately indifferent to a federally protected right, and that the defendant had actual knowledge. In the educational services context, 5 circuits decided that if a plaintiff was seeking injunctive relief or compensatory damages, they had to prove that the defendant acted with bad faith or gross misjudgment. And this came out of an Eighth Circuit case from a little more than 40 years ago called Monahan, which we're going to talk about in just a minute. But the holding in A.J.T was that the same standard that applies in other disability discrimination contexts applies in educational services cases. And so we'll go through just a little bit of the history that's relevant here and also was discussed by the court. So like I said, the bad faith or gross misjudgment standard came out of Monahan, a 1982 case from the Eighth Circuit, and it was a case involving Section 504 and the predecessor to the Individuals with Disabilities Education Act, which is shortened to IDEA. And the Eighth Circuit felt the duty to harmonize Section 504 and the predecessor to IDEA. So the court goes into this in the opinion in A.J.T, but there are 3 laws that protect disabled students: the Rehabilitation Act of 1973, the Education for All Handicapped Children Act, which has now been renamed and is termed the Individuals with Disabilities Education Act, or IDEA, and Title II of the Americans with Disabilities Act. The Rehabilitation Act and Title II essentially guarantee non-discriminatory access for students with disabilities, whereas IDEA guarantees public schools disabled students a free, appropriate public education, which is implemented through an individualized education plan. So Monahan decided, well, we have both at that time, the Rehabilitation Act and the Education for All Handicapped Children Act, so we feel the need to harmonize those 2 statutes. The Supreme Court pointed out that eventually they also grappled with the fact that there were at that time 2 laws protecting disabled students. At that time, the Section 504 and the IDEA's predecessor, and so they also tried to harmonize. And the Supreme Court held in a 1984 case, Smith v. Robinson, that IDEA was the exclusive avenue to challenge education-related discrimination claims. And Congress actually came back in 1986 and said, no, that was not our intent at all. And they added a provision, 20 U.S.C. 1415L, that's how it's been codified at this point, saying that IDEA does not limit the rights and remedies under Section 504 and now the ADA, except that plaintiffs who have claims under IDEA and the other statutes, Section 504 and IDEA, have to exhaust before pursuing those claims. So there was some discussion in the court's opinion in A.J.T, well, why haven't the circuits come back, the 5 circuits that have adopted this bad faith or gross misjudgment standard, in light of Congress amending IDEA and adding 20 U.S.C. Section 1415L, why haven't the circuits revisited their standard? And I don't think there was a clear consensus in the decision, or I'm sorry, in oral arguments. So now we get to the actual opinion in this case. It was unanimous and authored by Chief Justice Roberts. It discussed that nothing in the substance or remedial provisions of Section 504 and the ADA suggests that a different standard applies in education-related decisions. So with respect to the substantive provisions, you could see in the text of Section 504, nothing in here limits qualified individuals or says qualified individuals outside of the education context. The text just refers to qualified individuals. With respect to the remedial provisions, the remedies and procedures and rights available in Title II and Section 504 are available to any person, and there's no limitation on the type of case that's being brought. The court did not agree with the district's reading of the statute, so the district did a bit of a bait and switch at when the case got to the merits stage. The district argued that actually intent should be required for both injunctive relief and compensatory damages, and that the Monahan standard should actually is the correct standard for all disability related cases, which is very different than saying it's the correct standard only for education related cases. And the court said, no, in fact, we don't agree with that. And it's not consistent with what the Monahan court grappled with. The Monahan court was limiting, or it made its decision based on this unique context of education cases where there are these three statutes that protect disabled students. The opinion also acknowledged the challenges that disabled students face at the very end, and it acknowledged that this was a narrow decision, but an important one. So with that, I'm going to stop sharing.
And I'll just note, it's so interesting to read these cases together that we'll be discussing today, because the sort of bait and switch point you made, that at oral argument, the lawyer for the school district sort of changed the argument that originally had been presented, is something that Justice Thomas is very critical of in the Stanley case in the other context. So it's this but which was not, I think, commented upon here, is, if I recall, the opinion,
Yeah, so if I could clarify, it was actually at the merit, it wasn't specifically at oral argument, but at the merit stage that the district court, and yes, it was commented on extensively during the A.J.T. oral arguments. Justice Sotomayor asked, are you in violation of rule, I think it's 15.2, that says you should have brought this to our attention. Chief Justice Roberts said, is there a problem here that no one's actually defending the Monahan standard? And he got some laughs about that. So it came up in a number of different contexts during the oral argument.
Right. I guess just not in the written opinions itself, but yeah.
Right. Oh, yes. Yeah. No.
So based on, I always like to ask this question, I'll ask it of Corinne later. Based on your review of the briefs, and I know you attended oral argument, did you find this result surprising in any way?
No, the court referenced this in its opinion. The Monahan standard came out of the Eighth Circuit, and then this case also came out of the Eighth Circuit. And the Eighth Circuit, in the decision in this case, in a footnote, seemed sheepish about the standard in Monahan versus Nebraska. They said, we added a judicial gloss on Section 504. And they said Monahan is a lesson in why we do not add provisions to federal statutes. So, I think it's also worth noting that the U.S. government filed a brief in support and also argued in favor of A.J.T's position, or in favor of not adopting a two-tiered standard. Congress specifically amended IDEA to make clear that it was not meant to limit Section 504 and the ADA. And as I mentioned, it came up in oral argument. Why are the circuits continuing to follow this two-tiered system where there's a different standard in educational cases?
Yeah, and again, as we'll see in Stanley, where there's a lot of focus on textualism and actually a back and forth between some of the justices, I think one of the strong arguments here is there's nothing in the text to suggest that educational cases should be treated any differently, and perhaps that was significant to the court. So the 100th, I don't know, they keep saying like the $64 question, but I think with inflation that's a lot higher. So let's say the $1 million question. Why do you think this case is significant?
Like I said, the court itself acknowledged the significance. They said, students with disabilities face daunting challenges on a daily basis, and satisfying this more stringent standard shouldn't be one of them. Nearly 8 million disabled students attend public elementary and secondary schools, and so this case will ensure that they can bring these discrimination claims. Something that was brought up by an oral argument is that plaintiffs can take advantage if their jurisdiction has a lengthier statute of limitations for Section 504 and ADA claims, as opposed to IDEA, which is 2 years, then they can take advantage of that. But I mean, really, it's about, students will be able to hopefully remedy this, discrimination that they face in public schools.
Now, warning or trigger warning for you. I'm going to skip one question and go to your slide to ask about the concurrences, because although
Oh, sure.
This was a unanimous opinion, there were 2 concurrences and they were kind of interesting. I know you have a slide on that if you want to get to that.
Yeah. So there were 2 concurrences, one was by Justice Thomas, joined by Justice Kavanaugh, where he wrote, essentially that he would consider the school, there's the quote here, but he would consider the school district's arguments. And he repeated the school district's arguments with respect to the statute. He said, I do think that the statute, or he repeated the school district's arguments that the statute require intent, that the ADA and Title II of the ADA and Section 504 do. And then he also reiterated their arguments that there are constitutional considerations as to why intent should be required for all claims. Justice Sotomayor was joined by Justice Jackson, and she, I addressed that. I guess here, she does address that the school district made an 11th hour argument, and she pointed out that in the history and the text of Section 504 and the ADA affirm, or the statutes were adopted in part to address disability discrimination that is not the product of animus or intent, but instead comes from benign neglect or apathetic attitudes is also the term that she uses. And she spent some time pointing out that if a person with a disability who uses a wheelchair cannot access a building, then if the school district's requirement of intent were adopted, the wheelchair user would have to prove that the architect intended to discriminate against them, which would lead to absurd results.
Yeah, and I think what we're going to see, there's both the hint here, more than a hint from Justice Thomas and with Justice Kavanaugh joining him, that there may be some desire on the part of some justices to rethink the disparate impact standard, which Justice Sotomayor defended, as you mentioned. But also there's the executive order from the president supposedly saying, going against disparate impact more generally, I think particularly in cases dealing with race. So I think we're likely to see some movement on that. And I know advocates had some concern, not that Justice Thomas wrote, because I think that was not unexpected, but that Justice Kavanaugh joined him. And we don't know exactly what that means. The opinion is somewhat, I suppose, artful, right? And instead of saying, welcome arguments on this, which could mean I'm not decided, but I'd love to hear it, or could mean I am decided and I want a case on it. So, we'll have to see on that. Well, great. Well, we will come back to you, Caroline, in the later part of the program. But I wanted now to move on to Stanley versus City of Sanford, Florida, which I will be discussing. And this was an ADA case, Title I of the ADA, the employment provision of Title I. And for those more familiar with the Civil Rights Act of 1964, that's the somewhat equivalent of Title VII of the Civil Rights Act. This was a case regarding a firefighter who worked for the city of Sanford, Florida, who late in her time in employment developed Parkinson's disease. She did work for a few years after that diagnosis, but after a while was no longer able to perform the functions of a firefighter. I guess her Parkinsonism advanced, and she retired. And the issue for her was that at the point at which she had been hired and during much of her employment, the city had a two-tier system for providing retirement benefits for people who retired before they were eligible for Medicare at age 65. And that was that if you had 25 years in, you got full benefits from the time you retired until you were Medicare eligible. If, however, if you didn't have 25, you would only get 24 months coverage. But at least at the beginning, people who retired with disabilities would get the same rights, that same level of benefits as those with 25 years experience. And I think it was kind of clear that one of the reasons why Ms. Stanley wanted to work in this place was that she counted on getting those retirement benefits. Well, while she was working, the city changed its policy to do away with that equal provision towards the disabled firefighters, and just said, if you don't have 25 years in, whether you have a disability or not, you only get 24 months of coverage, which for people who might retire well before age 65, which I think would be not uncommon for firefighters, meant that they would have some period of time where they would have to get, wouldn't have benefits at all, which would be very risky, or have to get benefits in the private market, which could be quite expensive. So this was an issue that she faced. The issue, though, that as it came to the court was that she did not bring suit until after she was retired. And the question then became, well, is she a qualified individual with a disability? Because under Title I of the ADA, the person with a disability is defined as somebody who is able to perform the essential functions of the position with or without reasonable accommodation. So the issue was, by the point at which she had retired, and retired because of a disability, she was no longer employed and was no longer seeking to be employed, and indeed, one would say not qualified anymore to be employed. But the issue was, notwithstanding that position, could she still challenge what she claimed was a differential level of benefits, and saying that was discrimination? This case came up on a motion to dismiss, so there was an assumption that the policy, in fact, was discriminatory. I would say, while that is a common sense view, I think if the case ever got to or gets to the merits of whether the policy difference was in fact discriminatory, there's an open question, because by taking away the sort of, if you will, special treatment of firefighters with disabilities and just making it across the board, I think there's an argument that would say, well, that's not discriminatory because everybody under 25 years is being treated the same. I don't necessarily like that result, but I think it's not necessarily improbable to think that might happen. But in any event, that's not what the court got to. At this point, the court assumed there was discrimination involved. So what did the court wind up concluding? Well, one thing about this case, if you've had a chance to look at it, it's a very confusing set of opinions in this case. So Justice Gorsuch wrote the majority opinion in parts 1 and 2 of his opinion. And as to that portion, which was to reject the argument by Ms. Stanley and to rule in favor of the city of Sanford, it was a 7-2 decision, with Justices Sotomayor and Jackson dissenting. And for those who like to look at the conservative liberal split, interesting that Justice Kagan joined the majority in that portion. And that was the portion that I'll discuss in a minute, which basically said she was not a qualified individual at the time she brought suit, and consequently she could not bring the suit under the ADA. There was a part 3 to that opinion. This was now a plurality, so it was not a majority of the court. This was also written by Justice Gorsuch. He was joined by an interesting group, Justice Alito, Justice Sotomayor, and Justice Kagan. And what they did was, almost, you might say, this was the advisory opinion portion, in which they said, even though we don't think Ms. Stanley met the standard here, we can see other retirees could well bring a successful case under Title I under different circumstances, and then proceeded to go through and say why, in her case, those did not apply. So those were 4 justices who basically said, bad for Ms. Stanley, but not necessarily fatal to others who might be similarly or close to similarly situated. Justice Thomas, joined by Justice Barrett, concurred in part and concurred in the judgment. He was fine with the first part of the decision, but he would not have discussed ways in which a future plaintiff might be able to prevail. And as I alluded to earlier, he was critical of the parties having gone beyond the question presented in the case. And I'll explain in a moment why what they did and why he was critical of that. Justice Sotomayor concurred in part and dissented in part. She agreed with Justice Jackson that a retiree subjected to discrimination while she was still employed, could file suit after leaving employment, and noted that given Justice Jackson's position, there actually were 5 votes for that point of view. Justice Jackson dissented, with Justice Sotomayor joining parts 3 and 4 of her opinion, except for one footnote in part 4, which was Justice Jackson going off on the textualism that the majority used. So she did not join that portion of it, which again is kind of interesting. So kind of keeping track of the players and where they stand was actually one of the both fun things and sort of interesting things to do here. So what happened here? Well, the court decided that the language of Title I was such that you could not cover somebody who, at the point at which they sued, was not able to perform the essential functions of her job with or without a reasonable accommodation. And it based this on essentially the verb tense of the language in Title I, saying that Congress used the present tense, and they believed that to be intentional on its part. Consequently, you had to currently be able to perform the functions of the job, not had done so in the past. Although its language here is interestingly tentative. At one point, Justice Gorsuch said, the use of the present tense tends to suggest that the statute does not reach retirees. That's hardly powerful argument in favor of it. And later on, says, with regard to another assumption, well, it's considerably less plausible. So it's not a kind of hard and fast, if you will, confident decision in that way. It's really just saying, well, we don't, we're looking at this thing and we don't think it was meant to apply to retirees. To get there, in addition to looking at the tense that was used, the court looked at the examples of reasonable accommodations and discrimination that the statute talked about and said that all of these seem to really be related either to applicants for jobs or current job holders, and not with regard to people who had held a job. They did look at Title VII because, as I said, Title I of the ADA and Title VII of the 64 Civil Rights Act are pretty comparable, but there it said the 64 Act refers to employees generally, without any kind of time or temporal qualifier. And so we think they're in that case, because they had held that Title VII could be used by former employees. Here they said, well, they didn't do that here. So that means that's a difference that we think is significant. And said, again, that present tense was here. They also distinguished another case and said, again, it looks to us everything as you've got to be currently able to perform the job in order to really be qualified. So that's and they said, by the way, you're not lost, plaintiff. There's still things you could do. There's constitutional arguments. There's other statutes, which isn't, I suppose, very helpful. Now, the part that Justice Thomas objected to, part 3, the so-called advisory opinion, was where the court, the 4 justices said, look, normally we don't entertain questions like this, but we thought it might be useful. And there's 3 ways in which people who are currently retired could, in fact, successfully bring a claim under Title I. One was if the policy was adopted while the person was employed. Here, the problem is that when the policy changed, she did not have a disability. So at that point, she was not affected by it. They said that throws you out for that. The second prong, if you will, that you could be covered is if you were affected by a change. And that problem there was she'd already been retired for 2 years by the time she was affected by it, at least so they thought. And then finally, are you subject to the change? She was diagnosed in 2016, but worked until 2018. And that seems like the most plausible argument. But below at the 11th Circuit, the 11th Circuit concluded that she had waived that argument and essentially specifically disclaimed it. So they thought it was no longer in the case. And Stanley did not ask the Supreme Court to reevaluate or to reconsider that decision by the 11th Circuit. So the Gorsuch plurality said it really, maybe in another case we could go there, but it's not. It wasn't really presented here. So they did say, and I think this is somewhat, I don't know if it's naive or a throwaway, but Congress could amend the statute and address this problem if it wanted to. I think part of the problem with that is I think many advocates would be horrified to think of reopening the ADA for possible amendments, not this one, but other ones that might be opened up. Just real briefly, as I mentioned, Justice Thomas concurred, but said I wouldn't have gone to this advisory opinion. Justice Sotomayor said, look, I agree that there are circumstances where retirees should be able to bring cases here. Justice Jackson, and again, has become increasingly critical of the court. She criticized the outcome as a stingy outcome. She accused the court of rewriting the question that the plaintiffs actually presented here. She pointed out that the context in which Congress enacted the ADA is important, would have looked to legislative history, would have looked to the overall purpose of passing the ADA, which the majority kind of poo-pooed and said we look to language, not context. And also, though, said in the end, by the way, there also is a possible legislative response. So in that sense, I suppose you could say the majority and the dissent, while disagreeing on many things, did agree that this is something that could be addressed legislatively. So that's Stanley. I think one thing I'll say now, and before we turn to Kieran and LabCorp, is just there was a time in the past when there were challenges some years ago under the ADA regarding insurance coverage and the like, where the issue was, again, presented, who's in a position to challenge post-retirement benefits. And there was an argument made at that time that said that to be qualified here should be thought of as, were you qualified to get the benefit that you are claiming at the time when you were working and could do that? So that to be qualified in that context essentially is qualified as a benefits recipient, not qualified as an actual worker. That argument was not made explicitly here, but I do think it's one that has some potential. Because I think if you think about it, she did everything she needed to do as an employee to be someone who was entitled to benefits, and claims then that the cutoff was discriminatory. So that's in something of a nutshell, Stanley. And now we will tilt to an even more complicated case, if you will. LabCorp versus Davis. And Kieran, why don't you start us off with telling us what happened there, what the case was about.
Oh, well, thank you. Thank you very much, Bob, and greetings, everyone. I hope that you can see the screen I've shared with the PowerPoints, and I hope I'm able to navigate them properly. So as Bob might have mentioned, this is a very complicated case. I'll start with the court's decision. It's the outcome. And the outcome was dismissal of the writ of certiorari as improvidently granted, which thankfully is known as an acronym DIG. And Justice Kavanaugh also issued a sole dissenting opinion. But I'd like to start with explaining what a DIG is, and then turning to the factual background, and of course that complex procedural history, and then to oral argument highlights, and see where we are before I turn to Justice Kavanaugh's dissent. So I hope I can advance the screen. There we go. Thank you. So with a DIG, a court has concluded it was a mistake to grant review. And as here in LabCorp, for example, it was a bad procedural vehicle to get to the question. And through briefing and oral argument, that has come to the court's attention, once again, as happened here. So the writ of certiorari is dismissed, and the case proceeds as if review has not been granted. And similarly to other DIGs, the Supreme Court here issued a per curiam one-sentence DIG ruling that, again, was accompanied by a dissenting opinion by Justice Kavanaugh that we will get to.
Corinne, I'm sorry. To
Sure.
interrupt you, there was a question in the Q&A. If you could move your screen down a little bit, because somebody can't see your mouth because the name is blocking your mouth.
Oh, okay. I'm going to try to fix that. Don't think I can. With apologies, I don't know how to fix that. Maybe my name could be somehow removed. So I hope that's going to work, but I hope I'm able to be heard, and I hope the screen's able to be seen. I think that would probably be the most. I hope also there's closed captioning available if needed. So the factual background of this case, the case arose from a class action filed in California Federal Court, District Court, regarding LabCorp's self-service check-in kiosks as being inaccessible in violation of the ADA, as well as the California UNRRA Civil Rights Act, which provides for statutory damages. So LabCorp provides diagnostic laboratory services across the country. There's approximately 2,000 patient service centers, PSCs we'll call them, in the US, and about 300 of those are in California. Now, in 2017, LabCorp decided to install self-service touchscreen kiosks in a measure of efficiency and security and convenience, and they did place them in nearly all of their PSCs nationwide and in California. And the proposals that came in for these kiosks are interesting. One vendor did have an ADA compliant kiosk. So ADA compliant kiosks were available, but the kiosk that was chosen was from a vendor that offered a non-compliant, ADA non-compliant kiosk. And the services available through these kiosks included not just check-in for the laboratory services, but also updating contact information, also being able to provide a phone number to be able to be called back if you wanted to wait outside while you were in queue. But there was no auxiliary aids appropriate for effective communication for those who are legally blind. And LabCorp said, well, we gave the desk services the same technology available through the desk service. And there was always, as LabCorp put it, one employee on site to offer assistance if needed. But as the respondents said in their own personal experience, the front desk was allegedly not staffed in many locations. And there were certainly privacy concerns because after you hail the phlebotomist to the front, if you're able to, or if you have to rely on the kindness of strangers, so to speak, in the visiting area, they have to share their personal health information just to register out loud. And that certainly created a lot of privacy concerns. So the class action that was brought alleged that the services of LabCorp were not being provided in a full and equal way, full and equal terms, as to those who do not have the disability, namely being legally blind. So the U.S. District Court starts us on the road to this complex procedural history that results in a dig. And as they properly did, they divided the classes into two. There was a nationwide injunctive relief class, and there was the California statutory damages class, which is basically a subclass, seeking those statutory damages. So that under the state law, not available under Title III ADA, but the state law. So the nationwide injunctive relief class was of course, both classes met the Rule 23A requirements of numerosity, typicality, commonality, adequacy of representation. The injunctive class was certified under 23B2, which is the rule that provides for the classes typically in civil rights action, seeking injunctive relief that applies to the class as a whole. And the California statutory damages class, however, was under that higher, the more tough standard under Rule 23, 23B3 for damages actions. And the common questions there need to predominate. And of course, the wording of these two classes, just to set up our class definitions in the next slide, of course, are going to be the same, except for the geographical bounds, so to speak. So the nationwide injunctive relief is for the U.S. and California covers the California statutory damages cover California. So here we have again, another step on the road towards the dig. We have 2 certification orders with 2 class definitions, but 1 appeal, in a sense, just to put it pithily. So in May 22, when the district court recognized or certified these classes, the definitions for the nationwide and California classes were identical again, except for the geographic bounds. But it went as this: all legally blind individuals who visited a LabCorp PSC and were denied full and equal enjoyment of LabCorp's facilities due to the inaccessible kiosks. LabCorp petitioned for an immediate interlocutory appeal of the class certification on that May 22 order. And among its many arguments was that many of these class members lack Article 3 standing. In other words, that concrete particularized harm, because they did not attempt to use the kiosks, they did not want to use the kiosks, or they didn't even know about the kiosks. Now, in relation to those arguments brought up, the plaintiff respondents actually brought a motion and asking for kind of a revised definition, and the district court obliged, and in August 22 issued a second order with a modified class definition that those legally blind individuals who were unable to use the kiosks were members of the class. However, LabCorp did not amend or refile its petition for immediate appeal of the May 22, 2022 class certification order. So the Ninth Circuit Court of Appeals had in front of it the May 2022 order, even though LabCorp was presenting arguments on the subsequent order. But it had the jurisdiction over the May 2022 order. In a sense, that was what was in front of them. So they granted the petition to review, and they affirmed the class certification in an unpublished, non-precedential opinion, but they did affirm class certification. And in writing the petition for writ of cert, LabCorp presented to the Supreme Court, when we'll get to the question they presented in a moment, they presented on the August 2022 class definition. And so getting to the improvident grant of cert, the petition's question was stated as such: whether a federal court may certify a class action when some of its members lack any Article 3 injury. And just to pause here to differentiate, and during oral arguments, Justice Jackson echoes this point, that we're talking not about the class representatives, who of course need Article 3 standing, but rather class members at the certification level, not at remedial stage, but at the certification stage, that the class has to be defined to include only, or should not include, uninjured members, was the petitioner's argument. The Supreme Court, in granting cert, did narrow the question, and I think in a notable way. They focused on the state statutory damages class, that only under 23b3 should we be talking about this lack of Article 3 injury at the certification stage, just in posing that question. So of course, where the brakes got hit in this, because it's an interesting question, perhaps even though they had eliminated 23b2, it had echoes of other decisions that they didn't quite reach. The Supreme Court hadn't reached on this issue of standing and Title III accessibility cases. An amici brief was filed by a group of civil procedure scholars that includes Erwin Chemerinsky, and they pointed out this is a big problem. The wrong order was appealed. The May order was appealed. So there's these arguments about the August 22 or the later order, and May 2022 is what you have jurisdiction over, but May 2022 order is effectively superseded. And so are we heading to, as is going to come up in oral argument, are we heading to this advisory opinion here? So again, the petitioner was basically appealing on the wrong order, but arguing the right order. But procedurally, this is a very big concern. And so that leads us to the dig that I began with, the dismissal of cert as the writ of cert as improvidently granted. So getting to the issue presented, though, as well as, of course, this, of course, the threshold issue of whether they should even be looking at this question in this particular case.
Karen, can I just interrupt for one
Sure.
second? There's one suggestion, because again, about people being able to see your mouth. If you tilt your screen, that may help in being able to. Yes, exactly. There we go.
Okay.
I think that's, yeah.
Is that better?
I think so. So anyway, sorry to interrupt, but if we.
Oh, no, that's okay, and I apologize for the trouble. And oh, I got a thumbs up on that. Good. Okay, so hopefully that solved the problem. And again, appreciate you all letting me know this. I wouldn't have known. So the oral arguments on the issue presented, as well as there were, of course, comments about the threshold mootness or issue of why, what are we here for and what is the question, came up. That question came up early and often, but there also was, of course, comments on the issue that had been granted cert. So Justice Gorsuch raised questions regarding whether Article 3 jurisdictional requirements for injury and Rule 23 class action requirements were being conflated in this predominance argument. So he asked questions to kind of tease that out, and Justice Jackson again reminded the court that only in her question or comment, that only the class representative needs to show Article 3 standing. And she was joined by kind of an interesting array, but Sotomayor, along with Sotomayor and Justice Kagan Justice Sotomayor and Justice Kagan asking similar questions. Also, Justice Gorsuch also murmured about the court exercising jurisdiction over class members at the remedial stage. And so that's still the appropriate time to be bringing up standing issues regarding the class membership. So also Justice Gorsuch, kind of going back to his conflation issue, that these issues should probably be better handled under the predominance requirement, and Article 3 shouldn't have been brought in. So this is also, now what's interesting is injury the common issue that has to be common? Is there one particular issue that has to predominate? And so Justice Jackson once again reminded us that along those same lines, that it does not require, Rule 23b3 does not require a particular issue to be common and to predominate. So this idea that, oh, well, since we have to have this commonality and predominance, the common issues have to predominate, oh, this has to be the injury. So there was also questions regarding the practicality, or the very necessity of working out these Article 3 issues with class members at the certification stage. So would you like me to hop into?
Yeah, so again, as you pointed out, Kieran, this was a per curiam unsigned opinion, very short and sweet. But there was a dissent by Justice Kavanaugh, which I think raised some interesting questions. So briefly, if you could just talk about that.
I apologize if I'm going over here. So Justice Kavanaugh, I'll start kind of with the punchline that Justice Kavanaugh seemed intent on delivering, given that in the oral argument he actually kind of created a leading question, asked a leading question of the petitioner's counsel about this. He believes there's serious real-world consequences from overinflated classes, and that is, the coercion of businesses being faced with these class actions to kind of increase, have huge settlements as a result. And Chief Justice Roberts echoed that, saying, yeah, that's the elephant in the room in oral argument. But of course, real quick footnote counter to that is that could perhaps create the very preventative pressure that would have not brought them into court to begin with, to consider the consequences of these kinds of liabilities. But he believed that a damages class, he asserted that a damages class, once again, consisting of both injured and uninjured members, does not meet the predominance requirement under Rule 23b3 for damages classes. And he quoted a government argument, Amici argument at oral argument, that Justice Gorsuch actually took a pretty quick task to. And that is, if there are members of a class that aren't even injured, they can't share the same injury with other class members. So that was his the substance. Regarding how he got around the mootness, he said, and there was, a valid argument about this, that the May 22 order was still in effect because the August 22 order did not materially change or alter the first order. So that it was just a change in definition.
Yeah, so
like a tweaking of the definition.
right. I think he thought it was not really or to the extent there was even a possible issue of mootness, he thought that wasn't a required determination by the court, and that they could have actually reached this issue. It's a little bit ironic, I think, in our prep, you mentioned this, Kieran, that of course in Trump versus Casa, where they talked about challenging the universal jurisdiction, one of the things they said, well, of course there's always class actions, but this, not just this opinion by Kavanaugh, but in other opinions, they made it very difficult to bring class actions. And so query whether that's a real, how much of an option that's going to be.
Absolutely. And so definitely want to keep discussing that in the discussion, because that was the first thing I thought of when I was reading these concurring opinions in Trump v. Casa, where they're just emphasizing the availability of class actions. But Alito warned, but we really hold very strictly those, the Rule 23 cumbersome requirements. So, yeah.
Well, if you've gone to your doctor recently, you probably have had some interaction with LabCorp, because they're everywhere. And yet, again, and this goes back to an issue that whether for whatever reason people may want to use a kiosk, and for reasons of efficiency or privacy, that by being inaccessible to people who are blind or have low vision, it's denying them that opportunity. So they're not really being given equal level of services. So lastly, and not in as extensive a discussion as we've had so far, because it's not a decision, but it was a grant of cert late in the term, and that's the case of Hamm versus Smith. It's a death penalty case, and it's death penalty regarding a defendant who allegedly has intellectual disability. And in this case, the court granted cert on the following question: whether and how courts may consider the cumulative effect of multiple IQ scores in assessing an Atkins claim. And what does that mean? So very briefly, going back to 2002, the Supreme Court in Atkins versus Virginia decided that it was unconstitutional under the Eighth Amendment to execute a person with intellectual disability, but left to the states the question of how to define intellectual disability, which may or may not have been a wise thing on their part, because these cases now keep coming up. So the first post-Atkins challenge was in Hull versus Florida, which had to do with whether or not, if somebody has an IQ score of 70 plus or minus what's called the standard error of measurement, whether or not that was, unless you could prove that the person was below 70, that was dispositive about that the person didn't have intellectual disability. And the court said, well, first of all, get a score of 70 on this test. There's a standard error of measurement. It probably means that it's about 2/3 likely to be between a score of 65 and 75. Each test has its own standard error. But there's basically, you should not make decisions like this based on a score of 71 or 72, because that could well be a score below 70 given the way the test works. And the court said there, you have to look at also the adaptive element of the definition of intellectual disability. Intellectual disability is defined as 2 standard deviations below the mean on a cognitive test, plus limitations in adaptive behavior, plus having arisen before the age of 21. I'm paraphrasing. So the court said basically you can't treat 70 as some magic number. You need to look at the whole picture. Then later in Moore versus Texas, the court said the lower court had come up with a very odd definition of intellectual disability. In fact, one that seemed to be based on John Steinbeck's Of Mice and Men, of all things, and said you can't do that. You should look again holistically at the score on the IQ test, but also on the adaptive behavior. And the fact that someone can do some things well does not mean that there are not other ways in which they're substantially limited in their adaptive behavior. So the court has to look more generally. In Hamm, as I mentioned, the court is looking at now this kind of a narrower question, which is, well, what do you do if there's multiple IQ tests, some of which may be above the standard for being 2 standard deviations below the means, and some may be below. How do we deal with that? Should we consider cumulative effect of multiple scores in assessing a claim? Interestingly, the state of Alabama, which filed the cert petition, had actually proposed 2 questions. One was whether under Atkins, a defendant rather, had to show by preponderance of the evidence that the person had intellectual disability, as opposed to some lower standard that would give one cause to be concerned about this. The court did not grant cert on that. And their second question was whether courts evaluating multiple IQ scores must find that every valid score of about 75 or less supports an Atkins claim. Again, the Supreme Court did not grant cert that on those questions. The issue of multiple tests is an interesting one. And this is where I hope what we'll see is some amicus briefs from professional organizations. I'm thinking particularly of the ARC and AAIDD, explaining, for example, that if you continue to take multiple IQ test scores, your scores are likely to rise for sort of a practice effect. So that if, for example, the first few tests you take are, give you scores of 70 or 69 or 68, and then you get 74 or 75, that does not mean that somehow you no longer have intellectual disability. There's some nuance there. Interestingly, the court originally had this case and sent it back to the 11th Circuit and said, did you just determine, 11th Circuit, that as long as there was any score below 70, that was enough? Or did you look at it holistically? And the 11th Circuit on remand came back and said, oh, we did it holistically. So that may be, again, some indication of where they're going to go. This case has not yet been set down for argument. There was a motion granted to extend the period of time for a submission of briefs. So the petitioner's brief, the state's brief, is due August 4th, and the respondent's brief is due September 17th. So one would expect oral argument to be set probably late fall. It could be early spring, but I think probably late fall. And we'll see where this goes. Again, in looking at Atkins is now hard for me to even say this, 23 years ago. So both Justice Stevens, who wrote the opinion, and a number of other justices who were on the court at that time are no longer on the court. So the question of how this group will see this is kind of very much an open question. So as you can see, plenty of action on the disability rights docket, so to speak, and some of it dodging questions, some of it narrow questions. We do want to, we have some follow-up questions, but we also want to get to some of the questions in the chat. And I thought there were at least 2 that we wanted to address, I should say, in the Q&A. One is a series of questions from Brian East. And I'll take, I think, the last one, which says it most clearly. And that's this. The court recognized that most circuits use, this is for Caroline, I think, particularly. The court recognized that most circuits use the deliberate indifference standard in claims seeking damages, but the Fifth Circuit has rejected that without ever saying what the standard should be. Does the panel think that deliberate indifference will be expressly adopted by a future Supreme Court decision? So, Caroline, if you have an opinion about that.
I mean, I can say that it came up in the oral argument the court asked. There was a lot of discussion about the various intent requirements, and the court asked, do we need to go this far if we say that plaintiffs in educational cases don't need to meet this higher standard. Do we need to say what standard they do need to meet? So it certainly did come up, and now there is this concurrence by Thomas indicating that he would consider what the intent standard should be.
Yeah, I mean,
I
it's
don't know.
interesting.
I
No,
was just
go
gonna say I
ahead.
don't have a crystal ball, but it took 40 years to address the Monahan standard, so I don't know.
Yeah, I must say, and it, for whatever value, it's always been odd to me what even deliberate indifference means. It almost means being I mean, we know how it's become interpreted, but the language itself almost seems like I'm very consciously not paying any attention to something, right? I'm deliberately, it's like saying, putting your hands over your eyes or something, or maybe from the old Hogan's Heroes, I hear nothing, I see nothing. But I think so I think there was a little bit of like, what does this phrase even mean? It comes out also out of Eighth Amendment jurisprudence, particularly in the prison context where that was used, has been used pretty extensively. So to Brian's question, I don't, and like you, I don't have a crystal ball either. I didn't get the sense that the court as a whole was agitating to kind of review that. I think, I don't know, I have no real basis for that, but it seemed like Justice Kavanaugh was kind of almost, kind of just throwing out trial balloons, saying, "Hey, why do we even have this deliberate indifference standard?" But I don't know. I mean, I would be more. I think it's more likely that they address disparate impact because they're really signaling on that one than on deliberate indifference. But we'll have to see. And then there was a question regarding Stanley, and the question was as follows. As it relates to Stanley, it seems there are a lot of nuances. How narrow is this to the specifics of this plaintiff? Almost by definition of how short-term and long-term disability plans work, a person who must leave a job because of a disability, perhaps even a disability caused by that job, is not able to do the job. Under the kind of strict textualism this court espouses, is the individual instantly not a qualified employee? I think there I would say the answer probably we should be looking at that part 3 of the opinion that had the Justice Gorsuch of plurality, saying essentially there's several ways you can challenge a change in benefits. And again, it has to do with whether it was adopted while you were still working. That is, if it was a differential standard of insurance coverage or benefits coverage. If it affected you while you were there, and going to get to the third part, but sort of affected you, or also was adopted while you were there. So while you were still working, it's basically, it has less to do with whether or not you sued. The third was subject to, I'm sorry. It's less to do with the time when you sued, but whether or not while you were still working, the change was there. So for example, it seems to me, if you were employed and anticipating you would get certain coverage and benefits, and that was changed, such that you were then somebody affected by that while you were already at a disability, I think you do survive, at least according to the plurality. And I guess really, if they add Justice Jackson, there's 5 votes for it, that you could bring that case. I think the problem, and I alluded to it earlier with the benefits cases, is that they really, in the lower courts, did not do well. And even on things that seem really straightforward, like going back to earlier times where AIDS was really very much an issue, a employer who said, we will cover up to $1 million for health benefits for our employees, but for AIDS it'll be $25,000. And you saw things like that. So that seems really very blatant, just a difference based on disability. And a lot of the courts just said, no, not really. It's like it's applied to everybody. Of course, only the people who had AIDS would be interested in the AIDS coverage. I mean, it seemed to me to be kind of an odd thing, but those cases have not prevailed well, and have not prevailed. And I should say, at least one person's response, a disability rights lawyer's response to this decision, was essentially not surprised, because if it had come out otherwise, the financial cost to employers of not making distinctions in their benefits based on disability would have been astronomical. And hard to know about that, other than to say that as I've looked at ADA cases, the court has decided since the passage of the ADA, there are some cases that have gone well in terms of plaintiffs, many have not, but in particular cases that have to do with business, and that's often Title I cases, very much in favor of employers and not employees. And so this is not a case of like Casey Martin and the PGA or some of the other ones, or even a case like Tennessee versus Lane under Title II. But the Title I cases have really been kind of problematic. Let me just check to see whether there's any other Q&As that we want to address. And if not, I have some follow-ups. Okay, I don't see any really for the general group. There are some other comments, but I want to go back, Caroline, to you, if I can find my notes here. And again, I think maybe you could explain a little bit, kind of hinted at this, but most people think of if you're bringing a claim for discrimination in education for kids with disabilities, that IDEA is the place you would go. And yet we talked about at A.J.T that it was a case about ADA and 504. So why is that? Why does that happen? Why is it important that there be an ADA/504 cause of action when the underlying issue is one of, let's say, special education accessibility?
Sure. So why does there also need to be a cause of action? The fact that plaintiffs can get compensatory damages makes a huge difference. That is not available under IDEA. And then I think kind of the first part of your question is, why do we have this 3-statute scheme? And there are students who will not be covered by IDEA, but will be covered by Section 504 and the ADA. So for example, a student who uses a wheelchair may only need accommodations around having an accessible desk, but will not need an IEP to guarantee that they receive a free and appropriate public education. In other words, the student can access the content of the curriculum, but needs, in the sense of interacting with the curriculum, but would need assistance from the school in terms of making accommodations to access the physical environment.
Right. So it's both that there's people who may have claims that don't actually fit with the, if you will, the educational content so much as, for example, accessibility, and then also the damages issue. And this was the Perez case of several years ago, where the idea was, did you have to exhaust your IDEA remedies before you could bring your ADA case? And there was a kind of a catch-22, because why it didn't make sense to have to exhaust remedies that didn't exist, right? You could not get damages under IDEA. You get compensatory relief and other kind of relief, but not damages. So the idea that you could not bring a case under the ADA unless you'd exhausted remedies that weren't available for you never seemed to make a whole lot of sense. So the court found that to be true. But do you think it's going to, do you see this as generating a lot of additional litigation under ADA and 504 for educational related claims?
Potentially. I think, something we also touched on briefly earlier is that there can be a longer statute of limitations under ADA and Section 504, depending on the jurisdiction. As to the question of whether it will generate more litigation, I think there's definitely that possibility. I think something else that's worth mentioning is that it's a lot for a family and a student to endure to sue a school district under both IDEA and Section 504 in the ADA. And so if it will be a floodgate, as the school district seemed to argue, I don't know. I do wonder if it will prompt school districts to settle sooner, and given the lower standard, and or provide additional training to school district officials and employees about their obligations under the ADA and Section 504.
Yeah. So again, these statutes often exist have to be seen as sort of existing in some kind of coordinated type of way when you're thinking about, how to frame a claim here. And again, there was an IDEA claim in the case. It was resolved in favor of the parents, and then yet that didn't address the issue of damages. Kieran, I want to go to you. You clearly explain the sort of this kind of the technical issue, if you will, of whether people had Article 3 level standing or not. And I'm curious why it should, like, why should it be possible, maybe I'll put it this way, that even somebody who's not directly affected, didn't necessarily use the kiosk, should be somebody who should be at least be in a position of getting relief for alleged violations of the ADA. So somebody might look at and say, well, what harm is there to you? You didn't even know the kiosk was there, or you didn't even ask to use it.
Thank you so much for that question, Bob. So the oral argument revealed or touched upon this point that was raised in the respondents' briefing as well, and that is the rights, the violation of rights as the harm, that the inability, the lack of accessibility, it takes away choice. So you don't know about it, you don't choose to use it because it's not accessible. So no, you can't access it, you can't use it, you can't choose it either. And so the question then becomes, it's been recognized that violation of rights is an Article 3 injury, does give standing in terms of other types of discrimination, but not disability. And Justice Barrett reminded the counsel for the respondent that this is an unsettled issue and that disability discrimination doesn't necessarily map onto Title VII discrimination claims. But it would be good for the court to address it. They purposely, as was also revealed in oral argument by Justice Barrett, they purposely stepped away from looking at disability discrimination, Article 3 harm in particular. But my argument would be the denial of access to full and fair, full and equal access, that is, to the services and facilities is the harm. And from there flows the lack of use of the kiosk. So I would like to see the court arrive at that Title III issue that they seem to have been dodging.
Yeah, and there's been, I think, in other Title III cases too, again, concerns about when it's such an obvious barrier, how much specifically does the person have to subject him or herself to that to be able to demonstrate the barrier. So in this case, it is a physical barrier. We all, see it with inaccessible buildings. It's like, there's no doubt that it's inaccessible, and it may well be that the inaccessibility deters people from even going or using the procedure. So in this case, if you were blind or had low vision, whether you knew there were kiosks or not, why go there if you couldn't get access to it, right? So
right, exactly. So the futile gesture doctrine is kind of on the line in this with this question. So
right. And then real briefly, Caroline, we're just about ready to close, but maybe in 1 minute, you can tell us about the interesting contretemps, the oral argument in A.J.T between the lawyer for the school district and the lawyers for the other side, and the colloquy with Justice Gorsuch.
Sure. So the school district was represented by Lisa Blatt at oral argument, and she is the only woman attorney to have represented more than 50 clients before this, or to have argued more than 50 times before the Supreme Court. And she took issue with the way that the government and school district had characterized her argument, and actually said that they had lied. And Justice Gorsuch took issue with that once, and then said he was still troubled by what she said and asked her to retract her statement, which she eventually did, although the school district, when he got up for rebuttal, the attorney for the school district said that it was under duress. And so I think, so it was, it was an interesting moment. It was covered in some of the podcasts that covered this oral argument. And if you're looking for, just an interesting tidbit, it's worth checking out the oral argument.
Yeah, it was, and in the end, when she finally sort of agreed to withdraw the allegation, with Justice Gorsuch really pushing her on that, she said fine in the way that, a teenager might say fine to his or her parents about things. Anyway, so thank you for that. It was, an interesting point at the oral argument. So I want to thank Kieran and Caroline for your wonderful presentation and sharing your insights about these cases. And I want to thank the audience for your participation and your listening to us. If you found today's program valuable, we invite you to share the recording with your networks and explore other upcoming programs at americanbar.org/CRSJ. To stay connected with our work and help shape the future of civil and human rights advocacy, we invite you to join the ABA in the section of Civil Rights and Social Justice, and in particular, the Disability Rights Committee, which meets monthly on the fourth Thursday of every month, except for times when we meet at other times, and often, I think, a place for great discussion about what's going on in the disability rights world. We look forward to continue this important dialogue